My presentation today was intends to discuss what we might face in the post-arbitration scenario in the South China Sea. I think I have a. Thank you. So I will start with very briefly what we consider as the major causes for the South China Sea disputes. I think fundamentally we have this debating on the issue of legacy from the Second World War. We heard yesterday morning there is an audience from who is asking the impact of San Francisco Peace Treaty. I think that's exactly the treaty that all these claimant states base their claims, sovereignty claim on for the Vietnamese perspective, because this Article 2 of San Francisco Treaty actually put 5 categories of sovereignties that Japan is supposed to return to, but in Article 2F, then without mentioning to which country that the Spratly and parcel will be returned to. So Vietnamese perspective is based on the French colonial Annan administration. And then I think for the Philippines' perspective is based on the argument that I consider those Spratly, some part of Spratly as abandoned territory. And from Chinese perspective, because neither ROC or PRC were invited to the San Francisco Treaty, but there is a treaty signed between Japan and the ROC government in 1952, exactly the same day when the San Francisco Peace Treaty became effective. And then in that particular bilateral treaty, Article 2B and F, B is referring to Taiwan and Penghu, and 2F is referring to Paracel and Spratly. So that's how we consider that through this bilateral treaty that Japan is retaining those features to our ROC government. And certainly we hear a lot of geopolitical or strategic factors that we heard from yesterday, in addition to marine resources. And certainly on the law of the sea issues, and comes here. So this diagram actually shows how all these disputes categorized. With center, we have this sovereignty issue, which is not governed by the law of the convention. And then about this island regime, Article 121, and also how much effect that a small tiny island or features in the middle of the ocean might have, what kind of impact might have for the future delimitation. Those all are the issues that we are facing, and certainly what kind of baseline, normal baseline or straight baseline, and even archipelago baselines. And certainly there are the concepts, which is exactly what the conflict or what's the dispute between China and other claimant states about many kind of historical concepts where historical rights and historical water does not appear in any single provisions in the law of the convention except for some mentioned in Article 10, 15, and 298 of historical base and historical title. And also we have these territorial sea issues, and all these countries, they all respect in the same passage, except for some countries, they have domestic regulations on warship navigation. And on the EEZ regimes, all these countries, they base their claims on the EEZ regime, but we do share or have a lot of, maybe some interpretation on the military activity that Dr. Corning explained yesterday between U.S. and China. For example, we regarded not every type of military activity will be considered as radar navigations. And certainly there are also very important part 9 of UNCLOS, which talk about in the semi or enclosed sea or semi-enclosed sea, all the states are required to take regional cooperation when they exercising their rights and performing their duties. But this discussion on Part 9 has been overshadowed by the concept of islands regime and maritime delimitation. And then we have this very important part of issue of Part 15 about the dispute settlement under UNCLOS. It's a very comprehensive maritime dispute mechanism. And Part 1 requires all the states to choose for peaceful means to settle the disputes. And then Part 2, when all the states fail to reach consensus to solve their problem, then they're required to go to compulsory dispute settlement mechanisms. And then, but Part 3 will continue with there is a limitation and exception for the compulsory disputes. And I would like to spend 1 minute to explain what is the mystery of Article 298. I think the Laws Convention, with so many ratifying countries, signature countries, it actually came as a package deal that a country, in order to win something, you have to lose something. I think 298 exactly reflects what has been the outcome through the 30 years of negotiation. So basically, it gives a country a right to exclude certain types of disputes, including sovereignty issues, including maritime delimitation, military activities, and certain types of law enforcement from a compulsory third-party forum. I think that explains why many countries where they have concerns about whether they want to go to a third-party forum, but because of particular Article 298, it leaves a country a room to actually choose a way that it's preferred. So the idea of want to explain what is China supposed to international law, because we really heard a lot, everyone is calling China to act according to international rules and rules based in managing the issues in the South China Sea. So let me explain a little bit what is China's attitude or approach to international law. So that will be a breaking down into two phrases. One is from 1949 to 1978. So Chinese attitude towards international law has been bearing two distinct features: critical rejection and also positive construction. So on the one hand, China was very critical of traditional international law. They understood to primarily protect the interests of colonial and the so-called imperialist power to the detriment of most developing states. So China considered it as a developing state. But on the other hand, although China was precluded from taking seats in the United Nations back in before 1970, and China especially endorsed the purpose and principle of UN Charter and the principle of sovereign equality, peaceful, mutual respect. Well, having said that, I think I owed you explanation of what Professor Taylor explained yesterday when he said, well, China's foreign minister make a statement, China is big and other countries small. And I think there is a background on that sentence, and that sentence is only half of the original sentence. You know, when China have discussion, either bilateral or regional forum, and together with ASEAN states and China, we are describing like this, we are actually an Asian family. And then our neighbors come and say, well, very friendly discussion, China is big, and you are just kind of like a big brother in the family, and we are small, we're little brothers. So in Asian culture, the big brother is supposed to take care of the small brothers. So I think, well, by the way, there's not, that speech was not by Wang Yi, it was by Yang Jiechi, if we're talking about 2010. So his sentence, and I actually had the chance to talk to the people who are involved in the meeting, they said, Yang Jiechi's meaning, well, there's a fact, China is big in size and other countries are small in size. This is a fact that we cannot deny. But being big, meaning that it doesn't mean necessarily that we have to impose pressures to our small neighbors. And being small, it does not necessarily mean that you are weak. And this is a message implied in that statement. And so I don't think it's wise enough for a country's foreign ministry to make that kind of silly argument, saying that we're big, you're small. And that's why we have to. I think his message is because China has been taking very careful of the principle of sovereign equality. I don't think that's wise enough for him to make that. There's a misinterpretation. And also I want to speak a little bit about participation in UNCLOS. China only stepped into the negotiation in the middle of the whole negotiation. Although it has many concerns about the Law of Sea Convention, by signing the Law of Sea Convention might have some impact for South China Sea claims, but having a general cost and benefit analysis, and also back in that time, I heard many arguments. Some of the people who attended the negotiation does not know enough knowledge about Law of the Sea Convention. But anyway, China has been very actively participating in the UNCLOS process, so it has also drafted or passed many domestic legislation along with the Law of the Sea Convention, including its 1992 Territorial Sea Integral Zone Law and also 1998 EEZ and Continental Law. And in terms of marine legislation review, we will look at that. And in the South China Sea, we have a bunch of areas that covered by the Law of the Sea Convention. We're talking about marine pollution, we're talking about search and rescue, we're talking fishery management, and China has been signing I think, every single multilateral conventions in that regard. And then in terms of state practice of dispute settlement, because China is very clear, well, China decided not to participate in this arbitration case, and that's why that led to a lot of assumption. Everyone is saying or assume that China does not prefer a third-party compulsory dispute settlement. I think we have to understand this situation in the South China Sea. If we take, for instance, WTO negotiation, it's very interesting. The WTO process thought to be the most important indicator for the foreign scholars to study the changing role of China in the international legal order. So if we look at the WTO, they also have this compulsory dispute settlement mechanism. China has been very frequently using that mechanism to solve its trade issues. But when we talk about the South China Sea, we're talking about sovereignty issues, maritime delimitations in the context of South China Sea. I think it's rational to understand for countries has to take a second thought in actually leaving the issues, most sensitive issues, for a third party to make a decision. But having said that, I don't personally, from my own experience and my own perspective, I don't appreciate China's position not to participate from the very beginning. As a student of international law, we always think that why don't we use our knowledge about international law and about these mechanisms. I'm speaking too long, sorry. I hope I don't sound provocative so that I raise the right. But I think I do want to share with you, although I don't buy the position that China decided not to participate, but I think I understand why China did that. So China's position on the arbitration case, first of all, legally it's about the jurisdiction and about the admissibility. First of all, we believe that according to Article 283, there's not enough exchange between the two countries. So we have not exhausted the exchange of views. What has been discussing through the bilateral China and Philippine bilateral negotiation is about sovereignty, it's about maritime delimitation, and we never talk about how we're going to deal with individual features, whether it's an island or rock. So this had never been discussed by the two countries. And also Article 281 and 282, both countries agreed to cease settlement of dispute by peaceful means of their own choice. And I think for that part in China related to refer to a lot of regional discussion and also the DOC, that all the countries agreed to settle managing the issues by a peaceful means. And certainly, I think Chinese argument is also based on Article 298. Although the 15th submission in the Philippines showcase and trying to delink the issues from sovereignty and maritime delimitation, but China firmly believes without addressing the territorial issues, and those submission in the Philippines 15th submission will not be able to address. And I have plenty of arguments on jurisdiction admissibility, but unfortunately, because of the government's decision not to participate, so we kind of lost a chance to present the legal argument there. And the second reason why China choose not to participate is also about a legal culture of solving problems with neighbors. We heard yesterday a professor from Yale asking what China has previous experience of solving its land boundary issues. I think it's quite clear China has solved, among the 14 countries where China have this borderland, there has solved 12 land boundary issues. And certainly about the Gulf Tonkin is also one of the very good examples that China has managed to solve the issues on a bilateral basis. And the third reason is about arbitration's impact on confidence building that we see from 2013. I don't want to link all this post-arbitration development as a direct cause from the arbitration case. But what we're seeing after 2013 about the land reclamation activities, about this patrol, and about all these new shape of allies, I think it all have an impact on the confidence building, because at the end of the day, as Professor Arlene said yesterday, no matter what kind of decision that the tribunal may come up with, it's up to the country, up to China and the Philippines to come together again to negotiate how to solve the issues, the real issues between them. And this one just show you, if you're interested in the very technical issues about jurisdiction and marine issues, it simply give an idea that the islands regime submission 3, 4, 6, and 7 has been successfully entered into the marine phase, and also about law enforcement environment and the tribunal rule that they have jurisdictions. But on the issue of legality of China historical rights, and also the action of China as Philippines claim EEZ and continental shelf, and because the tribunal said they won't be able to decide whether they have jurisdiction without listening to the merit. So these all other issues, they were probably going to hear the results in the coming weeks. So I just want to make a little point here. I'm not very surprised that the island regime submission has passed through the threshold of jurisdiction, because there's no difference between China and the Philippines. Those little features China occupy right now or under Chinese control is very small. I don't think China would use it to claim EEZ. So there's no fundamental difference between the two countries. And I just want to show you, because everyone is talking about will the international community react if China does not enforce the decision or the award. So we're not there yet, but just want to give you an idea. If I try to look at a lot of these cases, in terms of non-compliance of state with international arbitration, and also from judicial decision, we see a lot of case, a boundary issue between Bolivia and Peru, and going to Anglo-Iranian oil company case, and case concerning right of passage of Indian territory. And all these cases, actually, I found there's a common pattern, which I summarize in a way. In the increasing number of cases, a party refused either to appear or to participate in the stage of proceeding, in the stage of either of the jurisdiction and the marine phase. And the unwilling participants was less likely than others to accept the court's judgment. And the dispute, especially dispute involving the land boundaries and the history of conflict, received the lowest level of compliance. Let me give you two examples. One is technical issues. Annex 7 of UNCLOS does not incorporate arbitration awards into domestic law. So the draft of UNCLOS decided not to incorporate arbitration awards rendered under Annex 7 into domestic law of the state. So while providing arbitration decision are binding on state parties, but the Annex 7 leaves the implementation and enforcement of the decision to the political body of state party. For example, in the UK's case, the case of UK virtually also required domestic legislation in order to incorporate treaties into the domestic law. Countries like US, following an intermediate approach that consider whether a treaty contains mandatory language, and if it does not, and it becomes domestic law. And for other countries like Kingdom Netherlands, incorporate many treaties concluded by executive branch into domestic law. And there are two cases. Do I still have some minutes?
1 minute.
Okay. So there are two cases, and one is 1996 Nicaragua-Colombia case, and when the U.S. participated in the phase of jurisdiction, but it decided to pull out when the ICJ decided that it has jurisdiction. There was also another case between Nicaragua and Colombia. So this is a territory maritime delimitation brought by Nicaragua against Colombia. So when the ICJ ruled that Colombia has sovereignty over 7 dispute islands in Western Caribbean, but granted Nicaragua control of a large amount of surrounding waters. So, and then Nicaragua decided to back out from that treaty, Bogotá cities. So this is my last slide. I think this want to show you what is the existing approaches for the region in terms of managing the dispute. We have negotiation, we have joint development, regional approach, and certainly we have also disputant. So it's the right time for us to consider how to resolve the issue between the claimant states. Take up upon again about Article 123 to foster regional cooperation and then leave the difficult issues aside and then making use of existing maritime cooperation fund. And certainly between the claimant states and user states, as I said yesterday, there's a lot of more common interests than differences that the country should look at. So with that, I will finish my presentation. Thank you for allowing me.